with your host, Mr. Uhel Barrickman.
Welcome to Glasgow Wants to Know. For those of you who were expecting to see the special meeting of the City Council at this hour, it will be on at 8:30 tonight. For our subject here this evening, we're going to be discussing the recent session of the Kentucky Legislature. We have as our guests the two representatives from Barron County to the legislature, the Honorable Walter Baker, who is a member of the State Senate, and the Honorable Steve Nunn, who is a member of the House of Representatives. Of course, we will be unable to cover the many subjects that were discussed in the legislature and the many bills that were enacted. So it's hard to decide where to start. I'm sort of like the mosquito in a nudist colony. I know what to do, but I don't know where to begin. But I'm going to begin with Representative Nunn, because, as most of you know, he was a co-sponsor of a health care bill. The bill which he helped sponsor was not enacted by the legislature, but a bill that contained, as I understand it, many provisions that were in the bill that he sponsored was finally enacted. And I'm going to ask him to briefly as possible, tell the audience what the bill that was passed does.
Okay, thank you, Uhel. And just to clarify, 250 is the bill that I did co-sponsor and was passed. It was the workers' comp bill that I helped co-sponsor that was later revised and brought about. But briefly, with House Bill 250, which is the health care reform bill, it's a bill that the governor had been pushing. We'd had a special session last year on it. We've been working for a year and a half on the problems with the health care system in this state, and of course they're looking at it nationally. The provisions of the bill, which are most significant, begin with the Health Care Policy Board being established. It's a 5-member board, 2 of which will be from the provider community. This board will oversee the delivery of health care in this state, and it will work to compile information through a data commission that we established last year in a special session. They will collect the information from insurance companies and from hospitals, doctors, nursing homes, the provider network, and for the first time we'll be able to correlate information from both the insurance industry and from the provider industry to determine what the cost drivers are in healthcare, to be able to bring together information on areas where we have overutilization and problems that need to be addressed in auto insurance and workers' compensation as well. This Healthcare Policy Board will have the ability to look at that information. The collection of data is extremely important, and in some points we'll be able to collect specific data in a non-identifying way for those that are concerned about personal privacy. They won't be able to collect information on a personal basis, but we'll be able to collect specific information. One of the things that is also in the bill is the Healthcare Purchasing Alliance. It is the ability to put large groups of state government, teachers, higher education into an alliance, and also allow then businesses and individuals that would like to belong to the alliance, they would hopefully be able to get cheaper insurance by combining their individual self or small group with a large block of other individuals, and thereby reducing their exposure. One of the most important things in the bill is the insurance reforms, which begin for the first time to level the playing field so that insurance companies cannot discriminate against individuals. It gives you portability. If you change jobs, you'll be able to take your insurance policy from one employer to another. It limits pre-existing conditions to 6 months, so if you have diabetes or some other medical problem, you will only have a 6-month waiting period, whereas now insurance companies can hold you at bay for a long time with those conditions. The insurance reforms are especially important for everybody to enable them to be treated fairly. The provider tax is a part of House Bill 250. It's certainly an inequitable and unfair tax on the providers in this state. However, in 2 sessions of the legislature where we've passed this tax, there has not been another viable alternative introduced by any member to be able to take the place of the provider tax. And at some point we're going to have to readdress that. One of the last things we did with the health care bill was with the Department of Insurance. We eliminated a loophole that had given insurance companies the ability to raise premiums based on prospective losses. And now insurance companies are going to have to be held accountable before they raise your rates and charge you more for your health care bill. So the Department of Insurance can review and approve insurance premiums. And I think that's a safeguard that we badly needed, and we were able to get it in at the last minute. I would say for those that are concerned about too much government intervention in the health care bill, that the power was deleted greatly from where we started with the bill to where we have ended up. And I think that government at this point is just in an overview position, and they're not going to take over the health care delivery system in this state based upon this bill.
Does it mandate coverage by employers?
No, it does not.
When does it become effective?
90 days after the governor signed it, and he signed it on the 15th, so I guess that's July 15th.
And will the alliance be formed immediately, or is there a time period in there before it becomes effective?
All of the time frames are staggered in to give the policies time to expire, and then upon renewal they'll be put into it. But I think the alliance is not started until July of '95 or some point close to that. There is in there that local officials, county officials, or employees will be put in, but there's a 2-year delay on them.
Senator, whether it's should be or should not be, there is a perception, I think generally among the public here, that this past legislative session was one of the least effective for many, many years. You've been there a long time, perhaps longer than you want to admit, but your head shows it. Do you care to comment about the perception?
Well, I think the perception has a great degree of accuracy. This was my 10th biennial session. It was by far the most difficult, the most tiring, the most onerous for me as a legislator in my participation. Bear in mind, I serve on 3 of the top committees in the Senate: Appropriations and Revenue, Education, and State Government, and each one has more than its fair load of issues. We did not pass a budget. That's the first legislature since 1956 not to do that. Did not pass a budget that will go into law. The governor vetoed it. The legislature, I think wisely, chose not to override that veto. We made some mid-course corrections in the Education Reform Act that I think are very desirable. We were, I believe in that area, we were responsive to the criticisms that many people have levied about problems with the education law, and I think tinkered with it in a way that hopefully will make it better. We passed a or the legislature passed, I did not happen to vote for it, a workers' compensation act which some say will at least cut down the increase in costs of workers' compensation, perhaps may even have an absolute reduction in workers' comp cost premiums for businesses. The bad part of that law, as I see it, is the legislature set up a state fund, and I believe the history in other states demonstrates that this is going to be a hole into which more and more public funds will have to be poured. But overall, I do not denominate this as a great legislature. I think it was one that did most of the usual type of lawmaking that has to be done, but I don't think there were any major bills, excepting perhaps health care, that got through this session.
Why?
Well, there are a number of reasons, and without being partisan, I think first and foremost there was an absolute lack of executive leadership. The governor was not a participant in the process in a forceful way. He is the only official elected by all the citizens of this Commonwealth, and he has a unique situation or position where he has the bully pulpit and he can lead the state if he chooses to. For whatever reason, I don't think this governor did. And I think that is a significant difference from previous legislatures that I have served in.
What about leadership in the legislature itself? First, I'll address the question to Representative Nunn in regard to the House. It appeared at times, at least to me, that there was almost a total lack of leadership in the House. Was I right or wrong in that perception?
I think you are partially right, Uhel. There was a lack of a unified leadership. Joe Clark, as Speaker, in his first term, was Joe Clark the man. He's never been a forceful leader figure. He'd always been Chairman of Appropriations and Revenue, and I think he was not aware of and not able to step himself up to that leadership position. And then there was a lot of factions within the issues that we were dealing with that created some turf wars and some animosity. Strong words were said during the session between House leadership and the governor and among the leadership, the Democratic leadership itself, and they were at several occasions at odds with themselves. And I think that in turn led to that feeling of no one was in charge of charting the course and plowing through the number of bills that we had to address. But I don't think any one person lacked the leadership. I think the issues divided them, and it was a combination of things.
It was obvious that there was going to be, and finally there was, a deadlock between the House and the Senate in the budget, over the budget. What brought that about?
That came about basically over the funding of projects across this Commonwealth. The House put in, I think, over $300 million of capital construction projects. Some, I think, are necessary and are projects that we should have done. Others were things that really had their source to capture individual legislators to vote for other pieces of legislation that they would prefer not to vote for. But they could go home and say, I got my 9-hole golf course, and that would partially justify their voting for some tax increase that they did not want to vote for. But the House came into the conference when the House and the Senate got into deadlock over the budget, and their basic negotiating position was, we want all of them or none of them. And the Senate said, you shall have none of them. Now that's not wholly true. There are some projects that both bodies agreed upon. But basically that free conference committee became a scorched earth committee in going through the budget.
What was the motivating factor in the Senate for saying, in that case, none of them?
Well, one is a historical factor in that the last 10 or 12 years, every year we've witnessed a shortfall in revenue and a reduction in the budget that had earlier been passed by the General Assembly. The senators did not want that to take place this time. I think they were a little uneasy about the revenue projections. They were determined that we would not use one-time money that will not be recurring year after year after year as a source of revenue to fund a capital construction project for which you issue bonds that have a life of 20 to 30 years. And the Senate just flat out said, no, we're not going to do that. And the senators in both caucuses, both majority and minority, were unwilling to adopt any additional revenue measures or tax measures that might have provided the recurring revenue that could have made that budget, even with the projects, a reasonably responsible budget.
Was there, in the House position, was there provisions for taxes to fund these projects that the House wanted?
Yes, there was. We passed in House Bill 455 a measure that would have tripled the tax on corporate inventory and machinery, and I voted against it, spoke against it, and the Senate didn't go along with it, and I want to compliment the Senate for their stance and holding firm on the measures that the House were pushing for, the measures being capital construction projects, mostly in eastern Kentucky, Louisville, a little bit in Lexington, and a convention center in northern Kentucky. But I believe, tongue-in-cheek, that had Senator Baker changed his position, we could have had the Kentucky Derby in Glasgow this year.
Well, it was my amendment that took the triple increase in personal property tax off. That was part of the House Bill 455 the House had adopted. I began receiving telephone calls from all over my district, and particularly from industry that was most affected by it. Very much did not want it. It was a rather extreme increase, tripling the tax from 15 cents to 45 cents per $100 on property that the corporations have. And the Senate just was not going to do that, and did not do it.
What's the prospect of getting a budget when the special session is called?
It's going to be interesting. I think that if we go about it with an open mind, the House having a position somewhat less than wanting everything or nothing, the Senate being willing to at least look at some reasonable funding mechanisms that are not, in my judgment, onerous on the taxpayers, I think we'll be able to get a budget, and a pretty good budget. But right now, I think it's better that that budget died.
I don't care which one of you answers the next question, or if it can be answered, but does anybody, either in the House or the Senate or in the executive office, have any reasonable expectation for revenues during the next year? We have the governor came along here with a projected revenue basis in his speech, his opening address to the legislature, and you all, as I understand it, have got a committee that makes the same projections, or at least comes up with projections about anticipated revenue. Then you get into a fight about it over this present budget, and then after you do not come up with a budget, or it's obvious you're not going to come up with one when the governor has announced he's going to veto it, and then they start talking about that you're going to have more income than they projected initially. Well, and you've already brought out the fact that for the last 2 legislative sessions, you overestimated the amount of revenue that was going to be received, and you budgeted more money than was actually received. Now, my question again, and I address it to either one that wants to answer the question, if it can be answered, is there anybody in Frankfort that knows what's going on?
Well, I'll take a stab at it. I think there are a number of people on the Appropriations Committee in the House and the Senate who have a reasonable comprehension of what's going on. I think in the governor's discovery of $30 million of additional revenue that had just suddenly grown out of nowhere, we're hearkening back to the very thing that Ned Breathitt did in 1966. And he had a revised revenue estimate, and they budgeted accordingly. And when Representative Nunn's father came in December 1967, the cupboard was bare, and the end result was that revenue had to be raised. And I don't want us to get into that situation. I don't think a majority of the Senate are willing to even run the risk of doing that.
I have a great deal of concern about the situation that we're in, as we have to go back into a special session to come up with a balanced budget sometime before June the 30th. And I think that the problems that we have, and for the first time we've had the executive branch actuaries and statisticians and the figure people together with the legislative branch. They got together and they couldn't agree, and when they did agree, then you got into fighting over who was going to get the slices of the pie and how much pie you could shove into it. And what we've done is to put ourselves in a situation where we may, 2 years from now, if we try and fund too many of these projects, we may be back to where we were in 1967. But the dilemma that we face is that we're not funding the Education Reform Act. Our maintenance and transportation system is crumbling around us. We're not funding all the human services that we've got programs out there in the state, and we're not funding them. And there's a lot of needs besides new bricks and mortar around the state. The University of Kentucky Library is a prime example. There's about $53 million in that one facility that they want to build, and most of that is in bricks and mortars at a time when technology is such that you could take that money and put that into computers and other things, and you could, instead of kids having to go to a facility, they could have access to that in their rooms or other parts, and we could do so much more with that money than to build a $53 million bricks and mortar building. And I think that our priorities are skewed, and we need to go back and refocus, because we're not doing the things for human services that we need. And our roads this past winter is illustrative of what's going on. We've got potholes, we've got interstates falling apart, the parkways are in need. And we've just got a lot of needs besides new golf courses and convention centers, and there's just a real dilemma that we're going to have to set our priorities for the next 2 years when we go back.
Well, I'll give you an example that in the Senate Education Committee, when we listened to the capital construction projections for education, elementary and secondary education in Kentucky, they supposedly documented an unmet need of about $2.2 billion in new construction that school districts wanted to embark upon. I started looking at that very carefully, and I discovered about 45% of that so-called unmet need was for construction that had absolutely nothing to do with teaching our students. It was for new buildings for the superintendent and the administrative staff. It was for new gymnasiums, projects like that. Projects would be nice to have, but the unmet need, I think, was grossly inflated. And we set about to try to instruct the State Department the next time they come back with realistic figures and not grossly inflated figures.
You keep referring to the CARA Act, indirectly or directly, which I think is good. There are certain features of it that have been put in question by many people, as you know. But my question now is, has there too much emphasis been put on that to the exclusion of higher education? What good is the ultimately? What good is Carroll going to be if you can't top it off by better professional and vocational schools after high school?
We have not funded the universities really other than just a basic continuation budget for a number of legislatures now. And that's going to come home to roost at some point. We'll start losing faculty. We'll flee to other institutions in other states. We'll be unable to attract the quality of faculty that we would like to have for Kentuckians. We're not paying our university people compared to our sister states and our comparable institutions anywhere near what they would receive were they teaching elsewhere.
Well, the university presidents have certainly been complaining about it, and they've been complaining for several years now. Is there anybody in Frankfort that's listening?
I'm not sure there really is. There are more teachers in elementary and secondary education who vote than there are deans and professors at regional universities in UK and U of L. I think most legislators have a much closer relationship with their local teachers and the teacher organizations than they do with the universities and their, or they really don't have a lobbying group. And that may be part of what they need. The graduates, the alumni of the universities may need to form themselves into some lobbying organization where they can have an impact upon the House and the Senate members. But so far they have not done that.
I'd like to comment on that because I think it's illustrative of the short-sightedness of the legislature that we're shortchanging our kids here in this state by not fulfilling or giving them a fulfilling and complete educational system. Education isn't K through 12 anymore. We need a college education for our kids. We need good colleges with good faculty and good staff and good facilities. And I think they've had a couple of budget cuts here in the last 4 years, and maybe they needed some belt tightening. But at some point, you've got to get them back into the process and make them feel that we know that the kids of Kentucky need them, and that's what it's all about. And I think that we're shortchanging our kids by building golf courses and maybe new state parks and not doing things that are going to help them be productive in their future years.
Well, there was about between $300,000 and $400,000 in the budget for an extended campus funding for Western Kentucky University. One of those extended campuses is right here in Glasgow. That was deleted in the scorched earth activity that the Senate did. I think, unfortunately, I would like to see it stayed in there.
Well, it's obvious that aside from whatever benefit the campus has been to Glasgow itself and Barron County, it has really helped particularly the older students that wanted to continue their education for 10 to 15 surrounding counties, and it keeps growing, and we need that. There's no doubt about it, but apparently nobody seems to be listening in Frankfort and in the right places. And now you've introduced something I was going to get to anyhow, and that is the effect of lobbying. You indicated that maybe universities needed to get a lobbying group together. Now, after the previous session of the legislature and dealing with lobbies and passing various laws about lobbying and also various ethic provisions and so forth, I'll start with Steve. Were lobby groups less effective in this legislature than they were in the other two that you've witnessed up there?
Well, effective is a relative term. There were still plenty of lobbyists in Frankfurt. In dealing with the health care bill, they were like 1,000 swarms of bees around, all of them with their special interests that they wanted to protect, and it was a dilemma that I hadn't faced 2 years previously, and there's never been anything quite as enormous as health care. Joe Clark said that he'd been there 24, 26 years, and he'd never tried to deal with an issue as complex. But it brought in just hundreds of people trying to influence and push information into the system. And I think that it was good. I think the ethics law is very good, and I support it. I think there's been a lot of publicity about it through the Herald Leader that's been detrimental, that it's not strong enough. I don't believe that it's not strong enough, and I don't believe that we have seriously weakened it here in this last session. But lobbyists are an integral part of the legislature, and the way I look at it, everybody who has an opinion is a lobbyist, whether they're paid by somebody or whether they're doing it out of their own beliefs and feelings. It's important to get that information. It's important for people to share with you their feelings about things. But I think that what we've done in the last session was, well, on the ethics session, and as we've moved to this session, it has been beneficial to the process.
Senator?
Well, we changed the ethics law in a couple of minor ways this time, and I think desirable ways. The Legislative Ethics Commission that was created last February in the special session had apparently adopted a stance that it was improper for a legislator to communicate with an administrative agency of state government on behalf of a constituent. That bill was modified to specifically allow us to do that. We are your representatives. When you have a problem with state government, whether it's a tax refund check that has not arrived in a timely manner or it's something else, you can go to your legislator, and hopefully the law will not prevent us from going to whatever agency it is and trying to get some action that would be affirmative and responsible. We modified the law to ensure that we can do that, and we modified it a little more than even the original bill proposed. It said a constituent, and I changed it in the Senate to a person. Many of us, particularly those of us who are senators, represent districts that change from time to time. For many years I represented Monroe County. It's no longer in my district. I still get calls and letters from people in Monroe County asking me to assist them, and I try to do it. That would have been cut off by some of the language there.
You think Monroe County might be in your districts again sometime?
Oh, that I don't know. They've never voted for me, but I still like them.
Got to protect yourself here. I understand that. Well, again, my question is, were the lobbyists any less effective this time than they have been in the past? In other words, did the legislation, and I'm not talking about the ethics as far as the members of the legislature are concerned, did the legislation that curtailed certain types of lobbying and tightened the law concerning lobbyists, did that improve the situation, or was it a waste of time?
Well, I think to some extent it may have improved the situation. We were not just, except on health care, where it was just a swarm of locusts every day, except on health care, we were not besieged by a large group of lobbyists on a daily basis. They were around, but they pretty well stayed hidden. They stayed over in the legislative cafeteria, stayed there so much, in fact, that the Parks Department that operates the cafeteria put up a notice that people were not to use the cafeteria as their offices. They were welcome to come and eat food or drink coffee, but they shouldn't stay there all day, which is what many of the lobbyists were doing. On the negative side, I do feel as an individual legislator that I was cut off from a free flow of communication with lobbyists that I have in previous sessions found very helpful. Not that I accept every bit of information the lobbyist gives me, but I can use that to weigh what another lobbyist is telling me and try to strike a balance as a judge does and find wherein the truth lies. We had less opportunity to do that this session simply because the laws prohibit, or they don't prohibit, but we legislators have interpreted it that we don't want anyone buying us anything. If they buy us anything, if they buy us a cup of coffee, they've got to report it on a form, and the newspaper's going to print our name, and Uhel Barrickman paid 50 cents at George Ellis Drugs to buy me a cup of coffee. And somebody's going to view that as improper. So that was the negative side.
And that's part of the change in the law that I was talking about. And personally, I don't think that has changed matters any.
No, I would agree, Uhel, that it hasn't hurt the effectiveness of lobbyists. And one improvement is and has been in this past session that the lobbyists no longer spend all their time in leadership offices. You were able to go into the offices and deal with legislators and staff, and you didn't have a lot of lobbyists that were just taking up space, basically, and I think it was good.
Well, I think that was good. There's no doubt about
So
that.
under Speaker Blandford, who now is in the federal penitentiary, many of the lobbyists made his office their headquarters. Blandford's no longer there, although toward the end of this session I heard several House members say, we wish we had Don back. He could make this thing work.
He did seem to have the ability to get a consensus. I don't know how he did it, but he did seem to do that.
Another change, or not, I don't know if it's a change, but something that's happened that's made a big impact on the General Assembly, is we have seen a number of our colleagues go to the federal penitentiary. We have seen in the caucus in which I sit in the Senate, one of the senators that started January with us by middle of February had been indicted and pled guilty and been sentenced on a felony in federal court. The leader of my caucus, between April 1st and April 15th, was indicted on 4 felony counts. Hopefully he's not guilty of any of them. But that puts a certain chill on anybody serving the legislature when you look around. A third member of the Senate, Senator LeMaster of the majority party, who sat behind me, left the Senate at 3 o'clock one afternoon. I chatted with him briefly as he was leaving. A little after 4 that afternoon, he was in handcuffs and shackles in the federal court, being led off to prison.
And you made some comment about that. You care to repeat that?
Well, I thought the federal judge went too far because most other people are not treated that way. But he chose to treat legislators that way. And the senator had indicated that he was going to appeal his conviction if he was sentenced. And now is appealing it and is out on bail because the higher federal courts let him get out.
And as I understand it, the reason they let him go and the reason for sending most of them after they're convicted direct to the prison is that after the federal court, appeals court, looks at the record, they don't think there's much chance of a reversal, but in his case,
they felt there's a substantial likelihood.
A substantial likelihood that that case would be reversed, which I can't help but saying here, and probably shouldn't because it's off the topic, but we hear about crooked lawyers and so much, you know, and of all the people that have been convicted, the only one that has been was LeMaster, the only lawyer in the group, and he wasn't convicted of bribing anybody but lying to the FBI. So I can't help but point that out. That,
defend your profession.
Have to defend
it's okay.
The senator's profession and my profession here. Well, we've talked about ethics. We've talked about a lot of other things. When we've mentioned the workman's compensation bill, I think perhaps both laborers here and employers and so forth would be interested in a little more explanation of what this new bill does do and its purpose. And again, I defer to you, Mr. Nunn, since you were one of the sponsors of the original bill, and I did get the two bills confused. But
yes, sir. Well, it was a tough bill from the beginning. We'd spent a number of meetings, the Labor and Industry Committee, working up to the session, and we had left it with Ron Cyrus to finish the drafting of the bill. And the bill didn't come before the House until we'd been up there for 30 days, and we got our first look at it. And the issues that we had agreed on in our meetings were not in accord with what was in the bill. So we started off with one hand tied behind our back trying to figure out where we were going. Later, the Speaker and other members of the House felt that we weren't progressing. We came up with another bill that did pass. The provisions in it included eliminating stress-related, psychological, and psychiatric injuries unless they are related to a work injury, to a physical injury. And that was one of the concessions that Labor gave up. There were others. We've got stricter limits on reopening of claims now. We're moving more towards managed care in work comp cases where the claims will go through a gatekeeper system, and we'll try to get away from so much doctor shopping and get the injured worker through the process and try and get them back to work. There were a provision to reduce benefits to injured workers as they reach age 65. Their awards would be decreased until they reach age 70, at which time they would receive, if they're totally permanently disabled, 40% of their original award. There was also some changes in the RIB benefits, which is the retraining incentive benefits to the coal industry.
What's the term in East Kentucky for that?
RIB, they call it a RIB benefit, but
it's the one that you buy your four-wheel drive and your boat with.
It's been terribly abused through the years. It's something that Labor's been very strong in the state of Kentucky, and the chairman of our committee is also the head of the AFL-CIO in the state. Certainly a conflict of interest that's never been adequately pursued. I don't see how he's been able to maintain that relationship, but at any rate, we've made some changes in the coal industry and what is allowable and compensable for them to try and level the playing field just a little bit. We've also we've had a doctor and a hospital fee schedule, medical fee schedule in place for several years in an effort to cut costs. There was a 25% reduction in the fee schedules as they now stand. We also put a $15,000 limit on attorney's fees. We cap attorney's fees at $15,000. There was strong effort made to reduce it down to $10,000, but that ultimately failed. And then there is some stricter time limits and some streamlining procedures for filing claims so that people need to be more time aware and get their claims in and not wait a couple of years or a longer period than would be reasonable before they file their claims. And then, as Walter spoke to earlier, it does include the creation of a competitive state fund, and I'd like to speak on that for just a moment, because myself being in the insurance industry, I'm aware right now that we only have 4 companies in the state of Kentucky who are writing workers' compensation in the voluntary market, which is the preferred market. And in that preferred market, of all the employers in the state, only 20% of them are in that preferred market. There is 50% of the market in the assigned risk, which is the higher risk market, and it's a very dangerous situation when you have that large percentage in there. The other 30% are in group self-insureds and self-insureds, which take care of their employees and provide their own workers' compensation. The competitive state fund will help to alleviate an assessment that the voluntary market has been paying in the assigned risk market to finance these companies, these businesses and employers, and the insurance companies that write in assigned risk. And it's been an unfair burden placed on the voluntary market, which has led us to having less and less companies. Companies are pulling out of Kentucky because they don't want to pay an assessment. The competitive state fund will help to remove that assessment, will allow more companies into the voluntary market. It will help to lower premiums for our employers here in the state of Kentucky. The only problem we have with this, it's going to take time. And a lot of employers are just borderline right now because their premiums are too high and they're struggling to stay in business. And it's going to take a year or 18 months, maybe even 2 years before we see the premiums that employers are paying to begin to decrease. And hopefully we can move quickly and make these changes and try and save as many businesses and employers here in the state.
You were talking about caps a while ago on attorney's fees. It's my recollection that you sponsored a bill to place a cap on the fees and salaries of county attorneys. What happened there?
That was House Bill 374. That was a very interesting bill, and the bill moved, and we had a lot of communications with the different county attorneys around the state. I tried to work closely with them to make sure that we didn't infringe upon their ability to collect child support, to cap attorney's fee, or county attorneys, excuse me. What we were trying to do is put a maximum amount of money that county attorneys could take as personal compensation at $63,000, and we made it through the House, and we attached an amendment which would call for the Auditor of Public Accounts to audit at least once every 4 years the records of all county officials. Currently they don't do county attorneys at all, and only occasionally do they do other county officials. We made it through the House through some maneuvering, and we're able to get it to the Senate. We got it through the Senate State Government Committee, and with Senator Baker's help we got it to the Senate floor, but there was a lot of personalities involved in the bill. Besides the county attorneys were becoming a little, the ones that had been taking as personal compensation large sums of money were applying pressure. Then there was a group that didn't want a representative in the House, Jim Wayne, to receive any credit, and they weren't in favor of Ben Chandler running for elected office, and the personalities took over, and the issue with the bill kind of took a sidestep, and there were leadership in the Senate that didn't want to tackle the issue and do the right thing, and the bill died. But and Walter was helping me, and it was an interesting fight, but it died the last day.
One very prominent member of the Senate leadership has a brother who's a county attorney, and that particular senator was never willing to, or he always had some reason why he didn't think this bill should be put up on the board and considered by the full Senate.
Now, you also had a bill to channel fees for collecting cold checks into the county treasury, I believe. How did that
That
fare?
bill passed, I'm very proud to say. It provides that the $5 to $10 cold check fee that has been going to the county attorney is money that belongs to the office, not to the individual county attorney. And it may be used for legitimate office expenses, and if there's any excess, it's payable at the end of the fiscal year into the county treasury to be used by the fiscal court for other needs of the county.
Now, with crime being such an important topic, not only locally but all over the country, I know that there were bills in the legislature, some of which passed, involving crimes in this state. Senator Baker, you want to talk about some of those bills?
Well, there was one bill which made it a felony for anyone to take a weapon to a school, and that includes students as well as adults. There was another bill which passed and which was vetoed by the governor, and the veto was not overridden, which would have said that 14-year-olds who committed major crimes or crimes involving the use of a firearm would be tried as adults up in the big court, up in circuit court, not shuttled into the juvenile court and then a hearing held to determine whether they had the maturity and the circumstances were such that they should be tried as adults. That bill passed, got a majority in the House and the Senate. The governor vetoed it, and at least in the Senate chose not to attempt to override the veto. I think wisely so. I think 14-year-olds ought to be in the juvenile court. The present law allows a mechanism to push juveniles upstairs under exceptional circumstances. The drive-by killings that we had in Paducah during the session, that's under the existing law. Those young men are going to be tried in the circuit court, in the big court, under the present-day law. So I thought our present law was adequate.
So essentially, there wasn't a whole lot done insofar as changing the statutes in regard to crime.
Not in the criminal law area, no.
I think in House Bill 390 the penalties were strengthened for felonies committed with the use of guns. And we also, I think, eliminated or made it against the law to sell armor-piercing ammunition and black talon ammunition here in the state, and that was part of that crime package, House Bill 390.
Any laws passed changing the statutes concerning elections?
There was a major, two major laws passed in the elections area. One was a bill that came from the State Board of Elections and from the Secretary of State, who's the chairman of the State Board of Elections, to implement the motor voter federal legislation that Congress has passed and we have to conform to. It will allow, or will require, registration when you sign up for your driver's license. You'll sign up, register to vote. When you sign up for welfare, you'll be registered to vote. Things like this, which I'm not sure we have much say on at the state level, that the feds have pushed down on us. There are some other changes in the election laws, but I'd have to have the bill out to get.
Well, weren't there some changes made about absentee voting, limiting the who could do it and under what circumstances?
I think that is tightened up. Yes.
Yes, that's correct. Only those that are disabled and
military personnel.
That's correct. But I think the people that formerly have been able to vote who were leaving town will, and I believe there's going to be a machine there or some way for them to vote, but I don't believe the absentee ballot's going to be sent out just because they are going to be out of town. I think they have to come into the clerk's office and vote.
And vote on a machine. That was the bill. I believe it was passed, but I'm not sure of that.
Yes, sir.
But I believe that was passed.
We got a bill through that I had introduced to allow, in the exceptional situation in which a candidate is running for office is unopposed by anyone in his or the other party, and then for whatever reason vacates the nomination, dies, is disqualified, is appointed to other office, in that unusual circumstance, we will now open the election list up to both parties to propose follow-on nominees. I had a lot of trouble getting that bill through because everybody thought I had a sinister motive because they knew Mr. Natcher was ill, and they thought I was trying to do something to change the rules there. It's a bill that I had proposed last July and had been unanimously adopted by the by the Elections Interim Committee. But eventually we got it through.
That would cure the situation that we had here last fall when Judge Redford became circuit judge, and then you had he was the only candidate by the Democratic Party and had won the primary, and no one had filed in the Republican primary, with the result that the Democratic precinct, or the Democratic county, well, the two counties, Metcalfe and Barron County, could nominate a Democratic successor, and he was bound to be elected without opposition.
And it also cures the situation in my party 4 years ago when Senator Jack Trevey in Lexington had the Republican nomination unopposed for re-election to the Senate, died in the summer, and the county committee of the Republican Party in Fayette County selected the successor nominee, who was unopposed, and is Senator Philpott, who was elected to the Senate. I think both situations ought to have been opened up, and in the future they will be.
And of course you had legislation regarding pregnant teens. Who wants to comment about that one?
The parental consent bill passed both chambers of the House, and teenage girls who get pregnant now have to have the consent of one parent or a legal advisor or a judge before she can have an abortion.
And by legal advisor, I presume you mean a guardian or a committee or something of that nature.
Yes, and go before a judge.
Any legislation concerning the workplace?
Well, there was a major workplace bill, but it was sort of a reshuffling in the cabinet, the workplace cabinet that now exists, and transferring of functions back and forth. One transfer that did not see light of day was the one on employment services. Was going to privatize that area and really eliminate the people who are there presently. And the legislature saw fit not to approve that, and employment services, which is now done by the state, will continue to be done by the state.
I believe I read somewhere, and I don't know what happened to this, that the legislature there was a bill in the legislature to create a commission that would be authorized to raise salaries of the members of the legislature.
That's not technically accurate. We reenacted a piece of legislation that had been there since, I think, the late 70s or early 80s. It sets up a commission that will recommend salary changes for legislators and other public officials, but those changes will still have to be approved and voted on by the General Assembly. They will not be automatic.
And insofar as raising salaries for the next terms, there was none of that in this session of the legislature, as far as I know.
The legislators have not had any pay increase either in salary or expense money since 1980.
But there was a bill enacted that affected when you could become eligible for pensions and things of that nature.
That bill, which I think Senate Bill 183, has been signed by the governor. It will allow for every 5 years you have been in the General Assembly, and also for judges, for every 5 years you have been on the bench, you may subtract 1 year from age 65 in reaching the age when you may retire without having a cut in whatever your earned retirement benefits might be.
No minimum level there.
But you may not go down below age 60.
Well, that could help you before long.
Well, that would be a great help to me.
Yeah, that could help
That
you
would be a
before
great help
very
to Judge
long.
Dickinson.
Yeah, it could. Yes, it could. Yes,
That is a great help to Judge Fuqua down in Logan County.
Yeah, I guess he could quit right now. I hadn't thought about that. Well, the time's about up. On behalf of the Electric Plant Board and WCLU, which also carried this, we thank you gentlemen for being here. If I may say personally, I think that considering everything, each one of you did a good job in Frankfort and well represented the community and your district.
Thank
both
you.
your Senate district and your legislative district. And
Thank
again,
you.
thank you very much.
Thank you.